My son-in-law burned my farm to the ground the night I refused to sell. The next morning, he stood in the ashes, looked me straight in the eye, and said, "Sign the papers. You have nothing left worth holding on to." I looked at the ruins of everything my brother and I had built with our own hands. 3 weeks later, he walked into a courtroom, certain he had already won. The door behind the bench opened. He saw my face. The folder in his hands hit the floor. "Thank you so much for joining Dad's Revenge Stories. I appreciate every single one of you. Let me know in the comments which city or country are you watching this from." Note this narrative features fictionalized details for creative and educational purposes. Similarities to actual names or events are coincidental, but the message carries clear value. The smell of pine hits me before my eyes are even open. 30 years of mornings on this land, and it still gets me the same way, that sharp, clean bite of mountain air rolling down off the ridge before the sun has cleared the tree line. I pull on my boots at the edge of the bed, the same worn pair I've had since Ray was still alive, and I step out onto the porch before the coffee is even done brewing. Aspen Ridge sits at the eastern shoulder of the San Bernardino Range, tucked into a fold of the California foothills, where the highway noise doesn't reach, and the nearest neighbor is far enough away that you can hear yourself think. Most people in town don't even know this property exists. It doesn't show up on the county's development maps. It doesn't belong to any homeowners association or municipal water district. My father founded it before any of that, and Ray and I built on it before anyone thought to look. I remember the summer we started. I was 34 years old, and Ray was 31, and we had between us one used truck, $2,000 in savings, and about 3 times more stubbornness than sense. We drove up the access road, barely more than a dirt path through the pines, and Ray jumped out of the truck before I'd even stopped it. Walked to the center of the clearing, spread his arms wide, and said, "Walt, this is it. This is the one." He always did know before I did. We felled the first trees ourselves, milled them by hand out near the eastern fence line, and stacked the lumber to dry through the rest of that summer. Our father came up twice to check on us, and each time he shook his head the way a man does when he's proud, but doesn't want to say so directly. We poured the foundation in September, framed the walls before the first frost, and moved in the following spring with no indoor plumbing finished, and a plastic tarp serving as the kitchen ceiling. Ray named the property Greer Ridge. I told him that was too on the nose. He told me I had no poetry in my soul. We compromised and never officially named it anything. What we did do on Ray's insistence was dig a proper well. Most of the surrounding parcels ran on municipal water, but Ray had read something about the aquifer sitting beneath this section of the foothills, a deep natural reserve that hadn't been touched by the development springing up around the valley floor. He spent 3 weeks researching it, drove down to the county water authority twice to pull the geological surveys, and came back each time more excited than the last. "Whoever owns this water," he told me one evening, sitting on the porch with a beer watching the sun go down behind the ridge, "owns this land forever. Nobody can push you out if you don't need anything from them." I thought he was being dramatic. He was being practical. The well came in at 240 feet, and the water was clean and cold and tasted like nothing at all, which is the best thing water can taste like. We capped it properly, filed the water rights with the state, and went back to finishing the house. Ray died 11 years later. Heart attack, quiet and sudden on a Tuesday morning in October. He was out checking the fence line on the north side of the property, and he just sat down against a post and didn't get back up. I found him an hour later, still in his jacket, with his coffee thermos set upright beside him, like he'd planned to come back for it. I buried him on the property under the big Douglas fir at the edge of the eastern field, the one he always said had the best view of the ridge at sunset. I planted a stone. I kept the thermos. After Ray passed, I let people assume what they wanted about my life. To the folks in town, I was the quiet old farmer on the hill, the one who drove a beat-up pickup, kept to himself, and had maybe retired from some government desk job nobody could quite remember. I never corrected them. I had spent 22 years serving as the chief judge of the Silver Ridge County District Court, and I had learned early that a man who advertises his authority invites people to test it. I preferred the other arrangement. I still drove down to the courthouse 3 days a week. I still signed orders, reviewed filings, and presided over cases that sometimes made the local paper. But I did it in a suit, and I came home in the truck, and I pulled off my tie before I hit the county road. And by the time I turned up the access road through the pines, I was just Walter Greer again, with boots that needed resoling and a porch that needed painting. That was the life Ray and I had built. Simple on the outside, solid underneath. The kind of life that doesn't ask for anything from anyone and gives back more than people expect. That was before my daughter brought home the man who would burn it all down. Melissa got her mother's smile and my stubbornness, and for most of her life that combination served her just fine. She grew up on this land, knew every trail through the pines, and could name the bird calls off the ridge before she was 8 years old. When her mother passed cancer slow and brutal the summer Melissa turned 16, my daughter didn't fall apart the way I feared she might. She cried hard for 3 days, then came downstairs on the 4th morning, made breakfast for both of us, and said, "Dad, we're going to be okay." She was 16 years old, and she meant every word of it. I raised her the best I knew how after that. She went to UC Davis, studied environmental science, called home every Sunday without fail. When she landed a job with a land conservation nonprofit in Sacramento, I drove down to help her move into her apartment and felt something loosen in my chest. The particular relief of a father who sees his child becoming exactly who she was always meant to be. She met Derek Calloway at a fundraising gala. She told me about him on one of our Sunday calls, her voice carrying that careful brightness people use when they're trying not to oversell something. "He's in real estate development, Dad. But he's different. He actually cares about sustainable building practices." I said that sounded good. I meant it at the time. I met Derek for the first time at a dinner in Sacramento, about 4 months after Melissa mentioned him. He was tall, well-dressed, with the kind of firm handshake that men practice in front of mirrors. He looked me straight in the eye when he introduced himself, smiled at exactly the right moments, and asked me 3 questions about the farm that were just informed enough to sound genuine. But I had spent 22 years on the bench watching people perform sincerity, and I recognized the mechanics of it. The way Derek's eyes moved when he thought no one was tracking them. The way he shifted the conversation whenever Melissa started talking about her work. The way he shook my hand, confident, calculated, like a man who had already decided what he wanted from me and was simply working out the sequence. I told myself I was being too suspicious. Melissa loved him. That counted for something. That counted for a lot. They were married 14 months later at a venue outside Napa, white tents on a hillside, 200 guests, an open bar that cost more than my truck. I stood at the altar beside Melissa and handed her to Derek Calloway with a smile that I held steady through sheer force of will, because she was radiant and she was happy, and a father's job in that moment is to get out of the way of his daughter's joy. At the reception, I watched Derek work the room. He moved from table to table with the ease of a man who understood that every conversation was a transaction. He remembered names, laughed loudly at the right moments, and kept one hand always lightly on Melissa's back, not out of affection, I realized, but out of positioning. She was part of his presentation. He found me near the end of the evening, standing alone at the edge of the tent, watching the lights of the valley below. "Beautiful property," he said, standing beside me. "Not unlike yours, actually. All that land up on the ridge." He paused, swirling his glass. You ever think about what you'll do with it eventually? Development potential up there must be significant. I looked at him steadily. I'll keep farming it, I said. Same as always. He smiled, easy, unbothered. Of course, he said. Just making conversation. But it wasn't conversation. I had seen enough men lay groundwork from the bench to know when a question isn't a question. He was taking a measurement, filing something away. I watched his expression the way I watched defendants during opening statements, not for what they said, but for what moved underneath it. Something moved underneath it. 3 months after the wedding, Derek called me directly, not through Melissa directly, and asked if I'd be willing to meet with his development team to discuss a project in the foothills. I told him I wasn't interested in any projects. He laughed warmly and said he understood completely, that he just wanted me to see the vision, no pressure at all. I declined again in the same sentence. There was a pause on the line. Brief, barely a full second. Then his voice came back smooth as before. Well, the offer stands, Walter. Family should always look out for each other. I hung up and stood in my kitchen for a long moment, my hand still on the receiver. Outside, the pines were moving in the evening wind, and the light was going gold across the eastern field, the same light Ray used to stop whatever he was doing just to watch. I thought about what Derek had said. Family should always look out for each other. A warm thing to say. The kind of thing that sounds like generosity and functions like a warning. I went back out to the porch and watched the sun finish going down. I didn't know yet what was coming. But something in my chest had shifted the way it shifts before a long case, that low settling weight of a man who understands he is at the beginning of something he will have to see all the way through to the end. The first envelope arrived on a Tuesday morning in March, about 6 months after the wedding. I almost missed it. I had been out since before sunrise checking the irrigation lines along the north field, and I came back to the house with mud on my boots and my mind still on the work. The envelope was sitting in the mailbox with the electric bill and a seed catalog, plain white, no return address printed on the front. Just the logo of the San Bernardino County Environmental Planning Office stamped in the upper left corner. I set the other mail on the porch railing and opened that one first. It was a notice of violation. 3 paragraphs of official language informing me that my property had been cited for improper groundwater discharge in violation of California Environmental Code, Section 13260, a regulation governing the disposal of waste materials near protected aquifer zones. The fine attached to the notice was $3,000 payable within 30 days, with interest accruing daily after the deadline. I read it twice standing on the porch in my work boots, and then I set it down on the railing and looked out at the well casing Ray and I had installed 30 years ago. That well had been inspected, certified, and registered with the State Water Resources Control Board. We had the paperwork filed in triplicate. There was no discharge. There never had been. I called the Environmental Planning Office that afternoon and spoke to a clerk who read me the same 3 paragraphs from the notice, then told me I could file a formal response within 15 days if I believed the citation was issued in error. I thanked her, hung up, and photographed the envelope and the notice front and back before I filed them in a folder I labeled simply documentation. That was the beginning of a habit that would eventually save everything I owned. The second letter arrived 11 days later. This one cited a violation of California Public Resources Code, Section 4291, the Defensible Space Law, requiring property owners to maintain cleared fire breaks around structures. The notice claimed my tree line along the western fence encroached within 30 feet of the main house. The fine was $7,000. I walked the western fence line that same afternoon with a measuring tape. The nearest tree stood 53 feet from the house. I photographed every measurement, uploaded the images to an encrypted cloud account I had set up through the courthouse IT department years earlier for sensitive case files and filed a second formal response. The third letter came 9 days after that. $11,000 for what the notice described as a structural hazard assessment failure. The claim being that my main house, constructed primarily of timber, did not meet current fire safety standards for rural California properties. This particular regulation, California Health and Safety Code Section 117.920, applied to structures built after 2008. My house had been standing since 1987. I was being buried in paperwork, designed to look legitimate. Each notice came from a real county office, cited a real regulation, and followed the correct procedural format. But the violations themselves were fabricated measurements taken from no inspection I had ever permitted, assessments conducted by no inspector who had ever set foot on my land. In California, a property owner can challenge environmental citations through the County Appeals Board, but the process takes 60 to 90 days per citation, and fines continue to accrue during the review period. Whoever was filing these complaints understood exactly how the system worked. I had a strong suspicion I knew who that was. Frank Morrow came by on a Saturday afternoon, about 2 weeks after the third letter arrived. Frank had the property directly south of mine, a smaller parcel, mostly cattle pasture, and we had been neighbors for nearly 20 years without ever becoming close the way good neighbors sometimes are. He was a quiet man, heavy-set with a gray beard he kept trimmed and a habit of bringing homemade deer jerky whenever he stopped by unannounced. He sat down on the porch steps and handed me a strip of jerky and said without any preamble, "You know, there's been a black SUV parked on the county road below your access trail twice this week. Different plates both times, but same vehicle. I've got a good eye for that kind of thing." I asked him what days. "Monday and Thursday," he said. "Both times around noon. Sat there for about 40 minutes each time. Nobody got out. Monday and Thursday were the 2 days the second and third violation notices had been postmarked." I thanked Frank, and he nodded and ate his jerky and didn't ask me any questions, which was exactly why I had always respected him. Before he left, he said, "You need a witness to anything that happens on that road, you call me first." I told him I would remember that. After Frank drove off, I sat on the porch for a long time watching the access trail through the pines. The total fines against me had climbed past $20,000. I had not paid a single cent. I had photographed every envelope, logged every date, recorded every phone call with the county offices, and stored copies of everything in 3 separate locations. One at the house, one in my courthouse office, and one on a remote server my IT administrator had helped me configure, so that access required 2 separate authentication keys held by 2 different people. Then, on a Thursday evening, I opened my email and found a message from Melissa. The subject line read, "Dad, please just read this with an open mind." The message was 4 paragraphs long. It talked about the stress of the citations, about the difficulty of managing rural property at my age, about how Derek had consulted with some colleagues and believed there was a fair solution that would protect my financial stability going forward. The language was careful and reasonable and touched all the right notes: a concerned daughter, a practical suggestion, a gentle nudge toward something she framed as common sense. But Melissa had grown up in this house. She had helped me file property paperwork since she was 12 years old. She knew what the well certification meant, and she knew what defensible space law required, and she had never once in her life described selling this land as protecting my financial stability. Those were not her words. They had the shape of her voice, but the logic of someone else entirely. I closed the email without responding. I walked out to Ray's tree at the edge of the eastern field, stood there until the sun finished going down behind the ridge, and made myself a promise that I intended to keep. Ray had a saying about paper. He used to tell me that a man's signature is his word made permanent, that once you put your name on something, you own it, the good and the bad alike. He said this so often when we were young that I eventually started treating every document I signed the way I treated testimony in my courtroom, carefully, deliberately, with the full understanding that words written down have a weight that spoken words do not. That belief is what sent me to the California State Land Registry office on a Wednesday morning in April, 43 days after the first violation notice had appeared in my mailbox. I had filed formal challenges with the San Bernardino County Appeals Board against all 3 citations. Under California administrative law, a property owner contesting an environmental citation must submit a written objection within 15 days of receipt, after which the county is required to schedule a hearing within 60 days. I had followed the process, exactly submitted documentation for each challenge, and was waiting on hearing dates. But I had also filed a broader complaint with the State Department of Conservation, flagging the pattern of citations as potentially coordinated and requesting a review of any recent boundary or title filings associated with my parcel. The woman at the land registry counter was named Patricia, according to her name badge, and she had the unhurried manner of someone who had worked in government long enough to find comfort in procedure. She pulled my parcel file, set it on the counter between us, and began flipping through the pages with practiced efficiency. She stopped near the back of the folder. "Mr. Greer," she said, and something in her voice made me set down the coffee I had been holding. "There's a boundary adjustment filing here dated 8 weeks ago. It shows a 15-meter realignment along your northern perimeter." She turned the document to face me. "It carries your signature." I looked at the signature line. The name written there was Walter R. Greer in handwriting that was close enough to mine to pass a casual inspection. The pen pressure was similar. The slant was almost right. But the R, my middle initial, which I have written the same way since I learned cursive in the 3rd grade, with a particular leftward kick at the bottom of the leg, was wrong. Whoever had copied my signature had not known about that kick. "I did not sign this document," I said. Patricia looked at me steadily. "I understand," she said. "You'll want to file a formal forgery complaint with our office and with the county recorder. I can give you those forms today." She paused. "There's something else." She turned to a second document 2 pages behind the first. "There's also a preliminary transfer agreement on file. It lists your daughter Melissa Greer Calloway as the transferring party for a portion of the parcel. Her signature is on the execution line." My chest tightened so sharply I had to press my hand flat against the counter to steady myself. "Does my daughter know this filing exists?" I asked. Patricia's expression answered the question before she spoke. "There's no way for us to determine that from this office," she said quietly. "But the filing was submitted by a third-party representative, not by your daughter in person." I took both documents. I photographed every page, standing right there at the counter with Patricia watching and saying nothing, because she understood, without being told, what I was doing and why. I filed the forgery complaint before I left the building, signing my real name on the form with the leftward kick intact, and I asked Patricia to make a notation in the file that the original filing was under dispute. I sat in my truck in the parking lot for 20 minutes before I started the engine. Melissa had not signed that document. I was as certain of that as I had ever been certain of anything. Her signature, the one I had watched her practice at the kitchen table when she was 10 years old, learning to write her full name for the first time, had a distinctive looping M that she had never changed. The M on the transfer agreement was printed, not looped. Derek, or someone working for Derek, had forged my daughter's name on a legal property, filing the same way they had forged mine. He had used her as an instrument without her knowledge, the way you use a tool, and the coldness of that settled into me like something heavy dropping through water. I called Melissa from the parking lot. The phone rang 4 times and went to voicemail. I called it again. Voicemail again. I sent a text message asking her to call me when she had a moment, keeping my words neutral, because I did not yet know how much she knew or how closely Derek monitored her communications. She did not call back that day, or the next. I drove home through the foothills with the forged documents on the seat beside me, and Ray's voice somewhere in the back of my mind, saying what he always said about paper. A man's signature is his word made permanent. Derek Calloway had put my word and my daughter's word on documents we had never touched, claiming property neither of us had agreed to move. By the time I turned up the access road through the pines, I had made two decisions. The first, that I would not confront Derek directly. Not yet. The second was that from this point forward I would treat every action he took as evidence, because a man who forges signatures on government filings is a man who will eventually forge something he cannot explain away. And when that moment came, I intended to have every piece of paper in perfect order. I went inside, made coffee, and added 2 new folders to my documentation system. I labeled the first one Forged Filings. I labeled the second one Melissa. That second folder was the one that hurt to make. Derek came to the farm on a Thursday afternoon in late April without calling ahead. I heard the car before I saw it. A black Mercedes SUV moving up the access road through the pines, too clean for the dirt trail, the kind of vehicle that announces money before the door opens. I was splitting wood near the barn, and I set the axe down and waited. I did not walk toward him. A man who shows up uninvited on your property can do the walking himself. He stepped out of the driver's side in a charcoal suit that probably cost more than my truck, holding a leather portfolio under one arm and wearing the particular smile of a man who has decided the meeting is already going his way. A woman got out of the passenger side a moment later, mid-30s, dark hair pulled back, a tablet computer in her hands, and an expression that suggested she would rather be somewhere else entirely. Derek did not introduce her immediately, which told me she was staff, not partnership. "Walter," he said, extending his hand as he crossed the yard. "I hope I'm not catching you at a bad time." "You are," I said. I shook his hand anyway because my father raised me to and because I wanted to watch his face when I said it. He laughed easy, practiced the laugh of a man who treats every obstacle as a minor inconvenience on the way to an outcome he has already decided. "Fair enough," he said. "I'll make this quick. I've had my team put together something I think you'll find genuinely compelling." He opened the portfolio and held it out to me. "A formal acquisition proposal. Clean terms, fast close, and a number I think you'll agree is more than reasonable given the current market." I took the document. I read it the way I read every document, front to back, every line, every footnote. The offer was for $420,000. The current assessed value of the property, including water rights, was just under $1 million. Derek was offering me less than half of what the land was worth, and framing it as generosity. "This is 43 cents on the dollar," I said. It accounts for the remediation costs associated with the environmental citations," he said smoothly. "Once those violations are on record, they affect the marketable title. We're absorbing that risk." "Citations you filed?" I said. His smile did not move. "I don't know what you mean by that, Walter." "I think you do," I said. I handed the portfolio back to him. "I'm not selling." He took the portfolio without looking at it, his eyes staying on mine. There was something behind them. Not anger, not yet, but a recalibration, the way a man looks when he has run a calculation and found that one of his variables is behaving unexpectedly. He had come here expecting a tired old farmer who had been ground down by 3 months of fines and legal notices. He had not expected a man who read the footnotes. "Sir Walter," he said, and his voice had shifted slightly, still smooth, but with something harder underneath it. You're not a young man. This property requires constant maintenance, and these citations are going to keep coming until they're resolved. That process is expensive and time-consuming, and frankly, he paused, tilting his head in a way that was clearly rehearsed. I worry about you trying to manage all of this alone. I've been managing alone for a long time, I said. I find I'm fairly good at it. He studied me for a moment. Then he nodded, clicked the portfolio shut, and turned back toward his car. It was only then that he gestured toward the woman with the tablet. This is Evelyn Nash, my executive assistant. She handles all the documentation on our end, so if you change your mind, she's your point of contact. Evelyn Nash looked up from her tablet when he said her name. She met my eyes for exactly 1 second, long enough for me to see that her expression was not the blank professionalism I had expected. There was something else in it. Discomfort, maybe. The look of a person sitting in a room where something is being said that they wish they had not heard. Mr. Greer, she said with a brief nod. Ms. Nash, I said. Derek got back in the Mercedes, and she followed without another word. I watched the SUV move back down the access trail through the pines, and I stood there until the sound of the engine had faded completely. That evening, I pulled up the Callaway Group's public business filings from the California Secretary of State database, something I had been meaning to do since the wedding and had not yet gotten around to. What I found was a company that had grown fast over the past 4 years, with a trail of acquired properties across 3 counties, several of them involving environmental citations filed against the previous owners in the months before purchase. The pattern was not subtle if you knew how to look for it. I also found buried in a subsidiary, filing a line item for a company called Pacific Baseline Survey Associates, the same firm name that appeared on the fraudulent boundary adjustment document Patricia had shown me at the land registry. I added Pacific Baseline to my documentation folders and went to bed. At 2 in the morning, I woke to the sound I had been half expecting since the first envelope arrived. I pulled on my boots, went out to the porch, and stood in the dark, looking at my cameras. Every single one of them, 4 units mounted on the barn. The gate post, the east corner of the house, and the woodshed had been sprayed black. The lenses were covered so completely that no light got through at all. Someone had walked this property in the dark and blinded every eye I had pointed outward, and they had done it without making enough noise to wake me. I stood there in the cold night air, looking at each ruined camera in turn, and I felt something settle into place inside me, not fear and not anger exactly, but the particular clarity that comes when a situation stops being ambiguous. He had just told me exactly how serious he was. I was back on the porch before sunrise. The 4 ruined cameras were still mounted in their brackets, barn gate post, east corner, woodshed, each one coated so thoroughly in black spray paint that no amount of cleaning was going to bring them back. Whoever had done it had used a flat finish paint, the kind that doesn't reflect light, the kind a person buys, specifically, because they don't want anyone to notice the coverage until they're already gone. That was not a spontaneous decision. That was preparation. I left the cameras where they were. Taking them down would tell Derek they had been noticed and replaced. Leaving them up told him nothing at all, which was exactly the informational position I wanted him in. I drove into town that morning and made 3 stops. The first was a hardware store on Meridian Avenue where I bought 4 battery-powered trail cameras, the kind hunters use for monitoring deer paths, small enough to fit in a coat pocket designed to operate for 60 days on a single set of batteries without any connection to a power outlet or a home network. The second stop was an electronics supplier on the edge of the commercial district, where I purchased 2 additional units of a different type, entirely compact cameras with built-in cellular upload capability. meaning they transmitted footage directly to a remote server the moment they captured motion without storing anything locally that could be seized or destroyed. The third stop was my bank, where I accessed my safe deposit box and retrieved a prepaid phone I had purchased 2 years earlier for courthouse security protocols and never used. I paid for everything in cash. Back at the farm, I spent the better part of the afternoon on placement. I put the first trail camera inside the hollow of the old Douglas fir near the gate-raised tree, the one I could see from the porch, angled toward the access road. The second went into the base of a wooden fence post along the north perimeter facing the service easement that ran behind the barn. The third I fitted inside the mouth of a ceramic owl I had owned for 15 years, sitting on the corner of the porch railing, positioned to cover the front of the house and the woodshed door. The fourth I tucked into a gap between two logs in the woodpile near the east wall of the barn, aimed at the barn entrance. The two cellular units I placed with more care. One went into a hollow behind a loose stone in the retaining wall. Along the driveway, a gap I had known about for years and never repaired, because Ray had used it to hide a spare house key, and I had never seen a reason to change that. The second I mounted inside a birdhouse on the fence post nearest the county road, angled down the access trail. Both units were set to upload continuously to a private server I had arranged through a former colleague at the courthouse, a man named Dennis who handled digital security for the court system, and who asked no questions when I called him because we had worked together long enough that he understood when questions were not the point. When I finished, I walked the entire perimeter of the property and looked at every camera placement from the outside, the angle a person approaching in the dark would see. I could not find a single one. I also went into the woodshed and screwed a small audio recorder to the underside of the shelf that held my hand. Tool's a voice-activated unit no larger than a pack of cards with a memory card that held 300 hours of audio and a magnetic backup drive I could pull out and replace without disturbing the recorder itself. If anyone ever entered that shed and spoke inside it, I would have a record. Frank Morrow came by around 4 in the afternoon with a thermos of coffee and the particular expression of a man who has been watching a situation develop and has reached the limit of saying nothing. "Saw your cameras got hit," he said, settling onto the porch steps. "They did," I said. "You putting new ones up?" "I've made some adjustments," I said. Frank poured coffee into the thermos lid and handed it to me. "I've been keeping notes," he said. "Dates, times, vehicles I've seen on the county road below your trail. I've got 11 entries going back to February." He reached into his jacket and produced a small spiral notebook, the kind you buy at a drugstore, its cover worn soft from being carried in a pocket. "Thought you might want a copy." I looked at him across the porch. Frank Morrow was 67 years old, a retired power line technician who had lived on the South Parcel for 2 decades and had never once asked me for anything. He was handing me 11 entries of documented observation because he had decided on his own, without being asked, that it was the right thing to do. "Frank," I said, "I'm going to need you to keep those notes somewhere safe. Somewhere that isn't your house." He nodded like that was the most natural thing he had ever been asked. "Already made 2 copies," he said. "One's at my daughter's place in Redlands. Other one's in my truck." I handed the thermos lid back to him, and we sat there for a while without talking, watching the afternoon light move across the ridge the way it does in late spring gold, and unhurried, like it has nowhere particular to be. Then the mail came. I walked to the box at the end of the drive and found 3 pieces: the electric bill, a seed catalog, and a plain white envelope with no return address. Inside was a single photograph printed on standard copy paper showing my house at night from a distance, taken from somewhere outside my property line in the dark, probably with a telephoto lens. At the bottom of the photograph, written in black marker in block letters, were 5 words: Old wood burns fast, Walter. I carried it inside, photographed it, bagged it in a Ziploc from the kitchen drawer, labeled it with the date and time, and added it to the folder marked Threats, Physical Evidence. Then I called Cole Hartley at the sheriff's office and reported it. Cole was a methodical man who I had worked alongside in a professional capacity for many years, and he listened without interrupting and said he would log it as a credible threat and increase patrol frequency on the county road. I thanked him and hung up and stood in the kitchen for a long moment, the late afternoon sun coming through the window above the sink, falling across the counter where Ray and I used to eat breakfast when we were still building this place and had nowhere else to sit. I was not afraid, but I understood, standing there in the quiet, that the man I was dealing with had just told me what he intended to do. And I had just finished making sure that when he did it, I would be ready. Melissa called on a Sunday evening 3 weeks after the cameras went dark. Her voice had that particular quality it gets when she is trying to sound casual about something that isn't casual at all. Slightly too bright, slightly too quick, the way she used to sound at 16 when she was about to ask me something she already knew I wouldn't like. Dad, Derek wants to have everyone over for dinner Friday. Some of his investors are going to be there and he thought it would be nice for you to meet them. Very low-key. Just dinner. I asked her who the investors were. Just some partners in the new project, she said. The Aspen Ridge development. Dad, I know things have been tense, but Derek really does want to work this out as a family. He asked me specifically to invite you. I said I would come. I said it because Melissa asked me to, and because I had not seen my daughter in 6 weeks, and because a man who refuses to walk into a room has already surrendered the ground inside it. I also said it because I had spent the previous evening reading through Derek's latest investor prospectus, a public document filed with the California Department of Financial Protection and Innovation, which outlined the Aspen Ridge Resort development in considerable detail. The prospectus described a planned luxury resort encompassing 412 acres in the San Bernardino foothills, including what it called a, quote, naturally occurring freshwater source of significant commercial value, unquote. My well, my water rights, filed in the prospectus as though they were already part of the project. I brought the prospectus with me. I also brought a certified copy of the official California State Boundary Survey for my parcel, the one filed with the State Lands Commission, bearing the Commission's seal showing the precise legal boundaries of my property as recorded in the public archive. I had requested the certified copy 3 weeks earlier, the same day I filed the forgery complaint, because I had suspected something like this evening was coming, and I believed in being prepared. Derek's house was in a gated community 20 minutes south of the farm. New construction, the kind of house that looks impressive from the street and hollow from the inside. The dining room table had been extended to seat 12. 8 of the chairs were occupied by men in their 50s and 60s, the type who wear expensive watches and talk about opportunity zones and carry themselves with the settled confidence of people who have spent their careers moving other people's money around. Derek greeted me at the door with a handshake and a smile, and said how glad he was I had come, and I told him the pleasure was mine, and we both understood that neither of us meant a word of it. Melissa hugged me in the hallway. She held on a beat longer than usual, and I felt the tension in her shoulders, the kind that comes from weeks of being caught between two people and not knowing how to stand. I wanted to tell her right there in the hallway what I had found at the land registry, what her signature looked like on that document, what Derek had used her name to do. But the hallway was not the place, and the evening was not the time. And I had learned a long time ago on the bench that the right moment to present evidence is not the moment you feel like presenting it. Dinner proceeded through 2 courses before Derek steered the conversation where he had always intended it to go. He stood at the head of the table and pressed a button on a remote, and a projection screen descended from the ceiling at the far end of the room. The image that appeared was a rendered architectural model sweeping rooflines, infinity pools. A main lodge with floor-to-ceiling windows overlooking a valley vista. At the center of the rendering, where the main lodge sat, was a parcel of land I recognized immediately. My barn, my woodshed, raised tree, Aspen Ridge Resort. Derek said with the ease of a man presenting something he considers already decided. 412 acres of premier California foothills property anchored by a natural freshwater source that eliminates infrastructure costs for the entire water system. He paused and looked directly at me. We're in the final stages of consolidating the remaining acreage. One of the investors, a heavy-set man with a silver tie, leaned forward. What's the timeline on that consolidation? Imminent, Derek said, still looking at me. I reached into the leather folder I had set beside my chair when I sat down and removed the certified boundary survey. I stood up, not quickly, not dramatically, just stood the way a person stands when they have something to contribute, and I placed the document flat on the table where the investors nearest me could see the commission seal. This is the official State Lands Commission survey for my parcel, I said, addressing the table rather than Derek. In California, a certified boundary survey carries full legal authority under Government Code Section 228 URB. It establishes the precise limits of what a property owner controls and what they don't. I turned the document so the boundary line was visible. The acreage shown in that rendering extends approximately 15 meters into land that belongs to me. I have not agreed to sell. I have not signed any transfer agreement. And any investor whose capital is committed to this project, based on the assumption that my land is available, should be aware that it is not. The silver-tied man looked at the survey, then at Derek. Derek's jaw tightened just once, just briefly, before the smile came back. "Walter," he said with a warmth so manufactured it almost had a smell, "this isn't the venue for this kind of conversation." "You made it the venue," I said. I picked up the survey, slid it back into my folder, and looked at Melissa. Her face had gone the color of chalk. Her hands were pressed flat against the tablecloth, and her eyes were moving between me and Derek, with the desperate focus of a person trying to understand something that keeps changing shape. "I'm going to head home," I told her. "Call me when you can." I shook hands with no one on the way out. In the driveway, I sat in my truck for a moment before starting the engine. Through the dining room window, I could see Derek talking, his hands moving, rebuilding whatever I had just taken apart. The investors were listening. Some of them were nodding, but two of them were looking at the window where I had been standing, and their expressions were not the expressions of men who had just heard a minor procedural complication. They were the expressions of men who had just been shown that something they thought was solid had a crack running straight through the middle of it. My phone buzzed as I pulled onto the county road. An unknown number. I answered. A text came through instead of a voice, 4 words, no punctuation, from a number I did not recognize. "You should have sold." The week after the dinner, Derek went quiet. No letters from the county. No calls. No black SUV on the road below my access trail. Frank checked twice and reported nothing, and the cellular cameras uploaded nothing unusual for 7 straight days. Just deer moving through the east field at dusk, and a red-tailed hawk that had taken an interest in the fence post nearest the road. After 3 months of escalating pressure, the silence felt less like retreat and more like the stillness before a storm front moves in off the mountains. I have lived at the foot of Aspen Ridge long enough to know the difference. I used the quiet time to work. I re-chinked the north wall of the barn where the mortar had cracked over winter, replaced 2 sections of fence along the eastern perimeter, and spent an afternoon clearing brush from the slope above the woodshed, a task I had been putting off for months. Physical work has always helped me think, and I needed to think clearly because something about Derek's sudden silence was pulling at the back of my mind, the way a loose thread pulls at the corner of a hem. A man like Derek Calloway does not go quiet because he has given up. He goes quiet because he has changed his approach. On the 8th day, Evelyn Nash called me. She called the landline at the house, not my cell, which told me she did not want the call appearing on any device connected to the Calloway Group's communications network. She spoke quickly in a low voice, as though she was calling from somewhere she could be overheard. "Dr. Greer," she said, "I want you to know that I am not calling in any official capacity. I am calling because I believe you are a decent man, and because there are things happening that I am not comfortable with." She paused. "There is a financial instrument that was executed approximately 6 weeks ago under your daughter's name. I don't believe your daughter initiated it or fully understands what it covers. I think you need to look into it." I asked her what kind of instrument. "A property insurance policy," she said. "Comprehensive coverage on the Aspen Ridge parcel. The named beneficiary is a holding company registered in Nevada. The policy was brokered through a firm that does regular business with Calloway Group." Another pause. "The coverage amount is $2,100,000. The farm's current assessed value, including water rights, is just under $1 million. I let that settle for a moment. In California, insurance fraud defined under Penal Code Section 550 as knowingly presenting a false or fraudulent claim or causing a policy to be issued under false pretenses carries a penalty of up to 5 years in state prison per count. Taking out a policy worth more than twice the value of a property under a spouse's name without their knowledge and then filing a claim after that property is destroyed would constitute fraud of a straightforward and serious kind. Derek had not given up on acquiring the farm. He had simply decided that if he could not buy it, he would burn it and collect the insurance instead. "Ms. Nash," I said, "how long have you been aware of this?" "I found the documentation 4 days ago," she said. "I have been trying to decide what to do with it." Her voice steadied slightly. "I made a copy. I have it somewhere he cannot access. I told her to keep it exactly where it was and not to discuss it with anyone inside the company. I told her that if she felt her position was becoming unsafe, she should contact Cole Hartley at the sheriff's office and use my name. She said she understood, and then she said something that stopped me cold. "Mr. Greer, there's one more thing. I have been keeping a record of certain internal meetings, audio records. I started doing it 4 months ago because I became concerned about some of the financial transactions I was being asked to process, and I wanted to protect myself in case questions were ever asked." She hesitated. "Some of those recordings contain conversations about your property specifically, about the environmental citations, about the boundary filing." My hand tightened on the receiver. "About the fire," she said quietly. I asked her where the recordings were stored. "On a device he doesn't know exists," she said. "I'll keep them safe." And then the line went dead, not hung up abruptly, but disconnected cleanly, the way a call ends when someone has said everything they came to say and does not want to linger. I stood in the kitchen with the receiver still in my hand for a long moment. Outside, the afternoon light was moving across the ridge in long golden bands, the same light that had fallen through this window every evening for 30 years, the same light Ray and I used to watch from the porch, after a day's work with cold beers and not much to say to each other, because we didn't need to say much. I thought about what Evelyn had told me. A policy worth $2,100,000, 6 weeks old, registered under Melissa's name without her knowledge with a Nevada holding company as beneficiary. The timing of it, 6 weeks before the dinner, before the final refusal, before the text message that said you should have sold, was not coincidence. It was sequencing. Derek had been building toward this for months, and the insurance policy was not a backup plan. It was the plan. I thought about Ray's thermos, still on the shelf above the fireplace. I thought about the stone I had planted under the Douglas fir at the edge of the eastern field, the one that had his name on it and nothing else, because Ray always said that a man's name was enough if he had lived it right. I went to my desk, opened my laptop, and began drafting a detailed summary of Evelyn's call time content, every word I could reconstruct with precision, and saved it to the encrypted server with a timestamp and a case reference number I assigned myself the way I would have assigned it to any matter that came across my bench. Then I went out to check the cameras. Every light was green, every unit was recording, and somewhere out on the county road below my access trail, I had the same feeling I used to get in the middle of a long trial when the evidence finally started pointing in a single direction, that the truth was beginning to accumulate faster than Derek Calloway could outrun it. The judicial conference was held at a hotel in Sacramento 2 nights and 3 days, beginning on a Wednesday. I had been scheduled to attend for months, a statewide convening of district court judges to discuss sentencing guideline updates and a series of proposed amendments to California rules of court. My name was on the registration list. My room was booked. Derek had known about it since Melissa mentioned it at dinner 2 months earlier, which meant he had known for 2 months that there would be a window of exactly 48 hours when the farm would sit empty and unwatched. Or so he believed. I checked into the hotel Wednesday afternoon, attended the opening session, had dinner with 2 colleagues from Riverside County, and went to my room at 9 o'clock. I lay on top of the covers fully dressed, staring at the ceiling, listening to the air conditioning cycle on and off, and tried to identify what it was that wouldn't let me settle. It wasn't one thing. It was the accumulation of things. The insurance policy executed 6 weeks ago. The silence after the dinner. Evelyn's voice on the phone saying the word fire in a tone that carried the weight of something she already believed was going to happen. The spray-painted cameras. The photograph of my house in the dark. The text message that said you should have sold. I got up at 11, packed my bag, and checked out of the hotel. The woman at the front desk looked at me with the careful neutrality of someone trained not to ask questions about departing guests, and I drove out of the Sacramento parking structure into a clear California night and pointed the truck south toward the foothills. I was 60 miles out when my phone lit up on the seat beside me. A notification from the cellular camera mounted in the birdhouse at the end of my access trail. Motion detected. Upload in progress. I pulled onto the shoulder of the highway, hands tight on the wheel, and watched the footage load on my phone screen. The image was dark and grainy in the way night vision footage always is, but clear enough. A pickup truck, dark-colored, moving slowly up my access road with its headlights off, moving the way a vehicle moves when the driver does not want to be seen or heard. I pulled back onto the highway and drove faster. The second notification came 14 minutes later. Same camera. The truck was leaving, moving back down the access road, still without headlights, faster now. I was 40 miles out. The third notification was not from a camera. It was from the smoke detection system I had installed in the barn 3 weeks earlier. A cellular unit tied to the same server as the cameras, programmed to send an alert if particulate levels exceeded a fire threshold. The alert read, "Smoke detected barn sensor," and the timestamp showed it had triggered 4 minutes after the truck left the access road. I drove with both hands on the wheel and my jaw locked tight and said nothing out loud, because there was nothing to say. I saw the glow from 8 miles away. A deep orange pulse against the dark ridgeline, the kind of light that has nothing to do with sunset or street lamps or any natural thing, and the kind of light that means something is being consumed. My chest felt like something was sitting on it. I pressed the accelerator to the floor and watched the glow grow larger and more terrible with every mile. By the time I turned up the access road, the barn was fully involved, and the main house was burning from the south wall inward. Fire trucks were already on the property. Cole had gotten there fast, which meant Frank had called it in, fast, which meant Frank had been watching the way he always watched. A sheriff's cruiser was parked at the gate with its lights turning. Neighbors stood along the fence line in their coats, faces lit orange, watching the way people watch fires, unable to look away, unable to do anything useful. I parked and got out, and stood at the edge of the gravel drive, and looked at what 30 years of work looked like when it burned. The woodshed went first. It was already caved in by the time I arrived. The roof folded down into itself like a crushed paper bag. The main house was going from the south end, the fire moving through the interior with a speed that told me it had been given help. Ray's tree was visible at the edge of the east field, untouched, the stone at its base, catching the firelight and throwing it back orange. Frank appeared beside me. His face was tight and his voice was low and controlled in the way that men's voices get when they are furious and frightened at the same time. "I saw the truck," he said. "Dark gray or black, no plates I could read. Went up your road at 11:12, came back down at 11:29. I called Cole at 11:31, and I called 911 at 11:32. He pressed a folded piece of paper into my hand. I wrote it all down before I called. Times, direction, description, signed and dated. I squeezed his arm and could not find words for a moment. Derek arrived 18 minutes after I did, which was 18 minutes too fast for a man who claimed to have been asleep at home when his phone rang with the news. He walked toward me across the gravel with his face arranged into an expression of shock and grief so precisely calibrated that it would have convinced anyone who did not know what grief actually looked like on a human face. "Walter," he said, his voice thick and practiced. "I am so sorry. I came as fast as I could." I looked at him. The firelight was moving across his face, and his eyes were bright with it, and for just a fraction of a second, less than a breath, barely a flicker, I saw something underneath the arranged expression that was not grief and was not shock. It was satisfaction. "You came fast," I said. He blinked. "What?" "You came fast," I said again, and turned back to watch my house burn. Behind me, the roof of the main house gave way, with a sound I will carry for the rest of my life, a deep structural groan, followed by a crash that sent a column of sparks spiraling up into the dark California sky. And somewhere in the woodshed, ruins under 6 inches of ash and collapsed timber, a small green light continued to blink. The fire was out by 3 in the morning. What remained of the main house was 4 partial walls and a chimney standing in a field of ash and collapsed timber, the metal roof folded inward and fused to the floor joists in places where the heat had been most concentrated. The barn was gone entirely, nothing left but the concrete foundation pad and 2 steel door hinges lying in the cinders. The woodshed had come down on itself, its roof and walls compressed into a blackened heap that still breathed thin ribbons of smoke into the cold night air. I sat in my truck at the edge of the gravel drive until the last fire crew packed their equipment and left. Cole Hartley came and found me there around 2:30, knocked on the window, and I rolled it down. "You need somewhere to stay tonight?" he asked. "I'm staying here," I said. He looked at me for a moment with the expression of a man who wants to argue and knows better. "I'll have someone back here at first light," he said. "Don't touch anything in the burn area." I told him I understood, and he left, and I sat in the truck alone with the windows cracked and the smell of wet ash coming through the gap, and watched the property. The way you watch something you love, after it has been damaged, looking for what is still there rather than what isn't. At 5:15 in the morning, when the sky above the ridge had gone from black to the particular dark blue that comes just before dawn. I got out of the truck, pulled on my work gloves, and walked to the woodshed ruins. The cellular camera I had mounted behind the loose stone in the retaining wall along the driveway had survived intact. The stone had protected it from the direct heat, and the unit had continued uploading throughout the night. The birdhouse camera at the end of the access trail was undamaged, but it was the camera inside the ceramic owl on the porch, railing the one I had thought was certainly destroyed, that mattered most. The owl itself had cracked and partially melted, but the interior cavity where I had fitted the camera unit had been shielded by the ceramic mass long enough for the device to complete its upload cycle before the heat overwhelmed it. I sat in the truck with my laptop open and accessed the server. The footage loaded in segments organized by camera unit and timestamp. I started with the birdhouse camera and worked forward chronologically. At 11:12 at night, a dark gray pickup truck moved up the access road with its headlights off exactly as Frank had described. At 11:16, two figures got out near the woodshed. The night vision rendering made the image grainy and flat, but the build and movement of the taller figure, the way he carried his shoulders, the particular angle of his head, was not something I needed a clear image to identify. I had watched that man move across a dining room 2 weeks earlier. Then I switched to the owl camera footage. At 11:19, Derek Calloway walked directly in front of the porch, close enough that the camera captured his face in the ambient light thrown by a flashlight he was carrying pointed at the ground. The image was not perfect. It was not a studio photograph, but it was clear enough to show the line of his jaw, the set of his mouth, and the fuel container he was carrying in his right hand with the particular careful grip of a person who does not want to spill what is inside it. I watched the footage 4 times. Then I closed the laptop and sat with my hands flat on my thighs and breathed slowly and deliberately, the way I used to breathe before I walked into a difficult courtroom. I had spent 22 years on the bench evaluating evidence. I understood what this footage was and what it was not. It was not by itself a conviction. A defense attorney would attack the image quality challenge, the authentication of the upload timestamps, and argue that a grainy night vision frame showing a man carrying a container proved nothing about his intentions. Evidence of this kind needed to be part of a chain corroborated by physical evidence at the scene, by witness testimony, by financial records, by everything else I had been building for months. But it was the link that connected everything else together. I called Cole Hartley at 6:15 in the morning. He answered on the second ring, which told me he had not slept either. "I have footage," I said, "from cameras on the property. I need to transfer it to you in a way that preserves chain of custody. In California, criminal procedure chain of custody refers to the documented sequence of possession and control of evidence from the moment it is collected to the moment it is presented in court. Any break in that chain, any period where the evidence could theoretically have been altered or tampered with, gives a defense attorney grounds to challenge its admissibility. I needed Cole to receive the footage directly from the server with the transfer logged and timestamped, so that no one could argue I had edited or manipulated it between the fire and the investigation. Cole arrived at the property at 7 o'clock, with a forensic technician from the county sheriff's department. The 3 of us sat in my truck, and I walked them through the server access, the camera placement, and the upload sequence, while the technician documented every step. When Cole watched the owl camera footage and saw Derek's face, he went very still in the way that experienced law enforcement officers go still when they see something they were not fully expecting. "Who else has seen this?" he asked. "No one," I said. "Keep it that way," he said. Derek arrived at the property at 9:45 that morning, walking across the gravel in clean shoes that had never seen a day of farm work. His expression arranged into something between sympathy and practicality. He stood at the edge of the burn area looking at the ruins of the house, and then he turned to me and said, in the voice of a man offering a reasonable solution to an unfortunate problem, "Walter, I know this is devastating. I've spoken with my team and we can have an offer drawn up by end of day. Get you out from under all of this." I looked at him steadily. "The most important things," I said, "were never inside that house." He studied my face, searching it for something confusion maybe or defeat, and found neither. For the first time since I had known Derek Calloway, he could not read the room he was standing in. He left without making an offer. Cole called me 4 days after the fire. I had been staying at a motel on the south edge of town, a clean, plain place with a parking lot that faced the highway and a vending machine outside my door that hummed all night at a frequency I eventually stopped hearing. I had my documentation folders with me, my laptop, the prepaid phone, and a change of clothes. Everything else I owned was ash. "I need you to come in," Cole said. "There are 2 people here who want to talk to you, and I think you're going to want to hear what they have to say." I drove to the sheriff's office and Cole met me at the side entrance, which told me he did not want this meeting going through the front desk. He led me down a short hallway to a conference room with a window that looked out onto the impound lot, and sitting at the table when I walked in were 2 people I had not expected to see together. Evelyn Nash sat on the left side of the table with her hands folded in front of her, and the composed expression of a woman who has made a decision she is not going to walk back from. Beside her sat a man I did not recognize, mid-30s, heavy-set, with a thick neck, and the particular posture of someone who has spent time doing physical work and is not accustomed to sitting still in small rooms. He was looking at the table when I walked in and did not look up immediately. Cole introduced the second man as Gavin Locke. Renee Stokes, the county's lead fire investigator, was seated at the end of the table with a legal pad in front of her. She was a compact, precise woman in her late 40s, who I had worked with in a professional capacity on 2 previous arson cases, and she gave me a nod when I sat down that communicated without words that the conversation that was about to happen was serious and that she had already heard enough to believe it. Evelyn spoke first. She set a small device on the table, a smartwatch, the kind with a built-in microphone that can record audio continuously for up to 14 hours on a single charge. She had used it, she explained, to record 41 internal meetings over the course of 4 months, beginning in February, when she first noticed Derek routing payments through subsidiary accounts in amounts just below the federal reporting threshold of $10,000, a practice known as structuring, which is itself a federal offense under 31 U.S.C. Section 5324, regardless of whether the underlying funds are legitimate. She had started recording to protect herself. She had continued recording because of what she kept hearing. Cole pressed play on the laptop connected to a small speaker at the center of the table, and Evelyn's recordings began to fill the room. The first clip was from a meeting in March. Derek's voice clear and unhurried, discussing the environmental citations as though they were inventory items on a checklist. "Third one goes out Thursday," he said. "If that doesn't move him, we go to the boundary filing." Another voice, a man I did not recognize, asked whether the old man had retained a lawyer yet. Derek laughed. "He's a farmer," he said. "Farmers don't win. He'll fold before spring." My jaw tightened so hard my back teeth ached. The second clip was from April. Derek's voice again lower this time, talking about the insurance policy. He named the Nevada holding company, gave the coverage amount, and said in a tone as casual as a man discussing a lunch reservation that the payout timeline after a total loss claim in California was typically 90 days, which was, he noted, enough time to break ground on the resort foundation if things moved efficiently afterward. The third clip was the one that made Renee Stokes set down her pen and look at the ceiling for a moment before she looked back at the table. Derek's voice from a meeting 2 weeks before the fire. "It needs to look electrical. Start it at the back of the barn and let it travel. The old wiring in that house will do the rest. Nobody's going to look twice at an old timber house with outdated wiring. The room was quiet for a moment after Cole stopped the playback. Then Gavin Locke cleared his throat and looked up from the table for the first time since I had walked in. He had the raw, uncomfortable expression of a man who has done something he cannot undo and has arrived at the particular moment of reckoning where the only remaining question is how much of it he is going to own. "I drove the truck," he said, addressing the table rather than any specific person. "I didn't set the fire. He did. I waited in the truck while he went in with the container." He paused. "He told me he'd pay me $80,000. He transferred $8,000 2 days later and stopped answering my calls." He looked up at me directly, then for just a moment, and what I saw in his face was not remorse exactly, but something adjacent to it, the expression of a man who had made a calculation that turned out to be badly wrong and was only now fully understanding the dimensions of the error. "I want to cooperate," he said. "I want whatever deal your office can give me, and in exchange I will tell you everything, every conversation, every instruction, every dollar amount, in whatever order you need it." Cole looked at Renee. Renee looked at her legal pad and wrote something without showing it to anyone. I looked at Evelyn Nash across the table. She had not moved since the recordings finished playing. Her hands were still folded in front of her, her posture still composed, but her eyes had the particular quality of someone who has been carrying something heavy for a long time and has just set it down. "Ms. Nash," I said, "thank you." She looked at me steadily. "He called you a farmer like it was an insult," she said. "I grew up on a farm in the Central Valley. I didn't think it was an insult." She unfolded her hands and pushed the smartwatch toward the center of the table. "Do whatever you need to with it." Cole walked me out to my truck afterward and stood by the driver's door with his arms crossed and a look on his face that I had seen before, the look of a law enforcement officer who has just watched a case go from circumstantial to something else entirely. "He doesn't know any of this is happening," Cole said. It was not a question. "Not yet," I said. I sat with that for a moment. Then something shifted in my chest. Not anger, not satisfaction, but the very particular feeling of a man who has just watched his opponent walk voluntarily into the only room in the building that was never going to work in his favor. I smiled. I could not help it. "Which court?" I asked. "Silver Ridge District," Cole said. I nodded and got in my truck and drove back to the motel, and for the first time in weeks, I slept. Chukchita. Before I reveal the shocking truth that unfolded right inside the courtroom, drop a comment with "still here" or the number 88 below, so I know you're still following along. And please note the following events contain some fictional elements added for artistic storytelling. If this isn't the style you enjoy, feel free to stop the video right here. Thank you so much. I had not worn the robe in 3 weeks. It had been hanging in the closet of my courthouse office, a second-floor room I had occupied for 11 years, with a window that faced the parking lot, and a shelf of case reporters along the east wall that I had never once found time to dust properly. When I walked in that morning and took the robe down from its hook, it felt both familiar and strange, the way a tool feels when you pick it up after a long absence, and your hands remember the weight of it before your mind does. I put it on slowly, straightened the collar, checked the buttons. Then I sat down at my desk and reviewed the filing one more time. Derek's emergency petition had been entered into the court's docketing system at 4:17 in the afternoon, 2 days earlier, assigned the next available case number, and routed to my calendar by the clerk of court according to standard procedure. Because standard procedure does not check whether the presiding judge owns the property named in the filing. The petition requested that the court grant Callaway Group emergency administrative authority over the burned Aspen Ridge parcel on the grounds that the ruins constituted a public safety hazard, requiring immediate remediation. It named the property owner as one W. Greer described as an unresponsive party. I had read it twice the previous evening and then set it on my desk and looked at it for a long moment, thinking about a man who had burned down a house and then walked into a courthouse to ask a judge to hand him the land it had stood on. He did not know who the judge was going to be. The courtroom filled quickly. Derek arrived with his attorney, a sharp-suited man named Patterson, who specialized in expedited property motions and had a reputation for moving fast and talking faster. Derek was dressed in a charcoal suit, a white shirt, a burgundy tie. He sat at the petitioner's table with the relaxed confidence of a man who has never once considered the possibility that a room might not go his way. He glanced around the courtroom with the assessing look he always wore in new spaces, cataloging exits, reading the room, measuring the distance between where he was and where he intended to be. He did not see me. I was not there to be seen yet. Melissa was in the gallery third row from the front on the left side. She was not sitting with Derek's associates. She was sitting alone in a dark coat with something small and rectangular in her hands that she was holding the way people hold things when they need to keep their hands occupied. I noticed that before anything else. The bailiff called the room to order at 9 o'clock precisely. All rise. The door behind the bench opened, and I walked through it. I heard the sound move through the room before I reached my chair, a shift, a murmur, a collective intake of breath from the section where Derek's associates were seated. I did not look at Derek immediately. I set my folder on the bench, adjusted the microphone, and sat down. Then I looked up. Derek Calloway was standing at the petitioner's table with his mouth slightly open and the folder he had been holding released from his fingers, its pages spreading across the table and drifting to the floor in the particular slow way that paper falls when a person's hands have simply stopped working. His attorney Patterson was already leaning toward him, speaking quickly and quietly into his ear, but Derek was not listening to Patterson. Derek was staring at the bench with an expression I had seen many times in that courtroom, the expression of a person who has just understood all at once, and without any remaining possibility of denial that the ground they were standing on was never as solid as they believed. His face had gone the color of old concrete. I allowed the room to settle. Then I spoke for the record. This is the emergency assignment session for case number CR 2847 Calloway Group versus W. Greer. I am Walter Greer, Chief Judge of the Silver Ridge County District Court. I am also the owner of the property named in this petition and the primary complainant in an active criminal investigation arising from the destruction of that property. I paused. Accordingly, I am recusing myself from all substantive decisions in this matter, pursuant to California Code of Judicial Ethics, Canon 3E, which requires disqualification whenever a judge has a personal interest in the outcome of a proceeding. Patterson was on his feet. Your Honor, I am not finished, Counselor. I kept my voice level. Before transferring this matter to an independent jurist from outside this county, I am exercising my emergency administrative authority under California Rules of Court Rule 10603 to issue a preservation order covering all records, electronic communications, financial documents, and digital devices belonging to or associated with Calloway Group and its subsidiaries. This order takes effect immediately and remains in force until a successor judge determines otherwise. The order had been prepared the previous evening. I signed it on the bench, handed it to the clerk, and watched two investigators from the county sheriff's department, who had been waiting in the hallway outside for exactly this moment, enter the courtroom and begin serving copies on Patterson and Derek's associates. Derek's mouth was moving, but no sound was coming out. Nolan Briggs entered through the side door, then a lean, unhurried man in his early 50s who served as a special prosecutor for the state attorney general's office and had been assigned to this case specifically because he had no prior professional relationship with me, ensuring that no one could argue my influence had shaped the prosecution. He stood at the back of the courtroom and said clearly enough for the gallery to hear that a criminal investigation into arson, real estate fraud, forgery of public documents, and insurance fraud was currently active, and that the court should be aware that additional charges were under review. Patterson grabbed Derek's arm and pulled him into a furious, whispered conversation that I did not need to hear to understand. Derek shook him off, his eyes still fixed on the bench. He looked at me with an expression I could not fully classify, rage and disbelief in almost equal measure, with something underneath both of them that might have been, for the very first time, fear. I gathered my folder from the bench and stood. This matter is transferred to the Honorable Patricia Weld of the Santa Barbara County Superior Court, who has agreed to serve as independent jurist. Her first session will be scheduled through the clerk of court. I looked at Derek one final time. Court is adjourned. I walked back through the door behind the bench without looking at him again. In the hallway, I leaned against the wall for a moment, my robe still on the folder in my hands, and let out a long, slow breath. Through the heavy door, I could hear the courtroom erupting into noise, voices overlapping chairs, scraping Patterson's raised voice, cutting through the rest. Then I heard something else. Footsteps behind me. I turned. Melissa was standing in the hallway. Her eyes were red, and her face was tight with the effort of holding something together that wanted very badly to come apart. In her right hand, she was holding a small black external hard drive. She held it out to me without speaking, and her hand was trembling so hard that when I reached out to take it, I covered her hand with both of mine and held it until the trembling slowed. We sat in a small conference room at the end of the hallway. It was the kind of room that courthouses keep for witness preparation. A rectangular table, 4 chairs, a single window with frosted glass that let light through without letting anyone see in or out. I had sent my clerk ahead to unlock it when I left the bench, because I had seen Melissa in the gallery holding that hard drive, and I had understood, without needing to be told, that whatever she had brought with her was not something that should be handed over in a corridor with Derek's attorney still in the building. I poured 2 cups of water from the pitcher on the side table and set one in front of her, and sat down across from her and waited. Melissa had her hands flat on the table now, both palms pressed down the way you press down on something to keep it from moving. And she was breathing carefully, the measured way people breathe when they are holding themselves together through deliberate effort. "He's been planning this since before he met me," she said. She did not say it like a question. She said it the way people state things they have already spent time verifying and no longer have the energy to be uncertain about. "Tell me what you found," I said. She had found the hard drive 4 days after the fire while she was clearing out Derek's home office. She had not been looking for anything in particular. She had been doing the mechanical work that people do when they need to feel useful and don't know what else to do. Emptying drawers, organizing files, carrying boxes to the hallway. The drive had been taped to the back of the bottom drawer of Derek's filing cabinet behind a false panel made from a piece of thin plywood, cut to fit the drawer dimensions so precisely that she had only found it because the drawer had stuck when she pulled it, and she had removed it entirely to check the runner. Inside the drive were folders organized by date going back nearly 4 years. The earliest folder contained market research on aquifer-fed properties in the San Bernardino foothills, geological surveys, water yield projections, commercial valuation reports for properties with natural freshwater access. My farm was identified in those documents by parcel number and described in a summary memo as the highest value undeveloped water asset in the target region. The memo was dated 14 months before Derek attended the fundraising gala where he met my daughter. Melissa's voice stayed level as she described this. Her hands stayed flat on the table, but her eyes had the particular quality of someone who has cried until crying stops producing anything, and what remains is just the truth sitting there in the open, needing to be looked at directly. He researched me, she said. There's a folder with my name on it, my educational background, my employment history, my relationship with you. There's a note in it that says, she stopped, pressed her lips together, continued. It says asset for property access, relationship with target landowner confirmed, approach recommended. The word asset landed in my chest, like something dropped from a height. I did not reach across the table. I did not tell her it was going to be all right, because she was 34 years old, and she deserved to be spoken to honestly. I said, he never deserved a single day of your trust. She looked at me then, directly for the first time since she had sat down. Her eyes were dry now, past the point of tears, and in them was something I recognized from the bench. The particular clarity that comes when a person has finished grieving a thing and has moved into the territory of deciding what to do about it. The drive also has financial records, she said. Internal Callaway Group accounts. Wire transfers to Pacific Baseline survey the company that filed the fake boundary maps. Payments to the environmental consulting firm that generated the false citations. And there's a folder labeled Legal Strategy that has emails between Derek and Patterson going back 18 months discussing how to pressure you into selling without triggering a harassment lawsuit. She slid the hard drive across the table toward me. I made 2 copies, she said. One is at my attorney's office. One is in a safety deposit box at the bank on Meridian Avenue. This is the third. I looked at my daughter across that small table in that plain courthouse room and felt something move through me that I could not have named, precisely not pride, exactly, though pride was part of it, and not relief, though relief was there too. It was closer to recognition, the same quality I had seen in her at 16 when she came downstairs on the 4th morning after her mother died and made breakfast for both of us and said we were going to be okay. She had been right then. She was the same person now. Your attorney, I said. Do they know the full scope of what's on that drive? I spent 3 hours with her yesterday, Melissa said. She's already filed for an emergency protective order on my behalf, covering all marital assets pending the criminal investigation. She also filed a motion to void the insurance policy Derek took out in my name on the grounds that I did not consent to it, and my signature on the application was obtained under fraudulent pretenses. Under California Family Code, Section 721, spouses owe each other a fiduciary duty of the highest good faith and fair dealing, and obtaining a financial instrument under a spouse's name without their knowledge constitutes a breach of that duty actionable in both civil and criminal court. Melissa's attorney had moved correctly and quickly. There's one more thing, Melissa said. She reached into her coat pocket and placed a folded piece of paper on the table beside the hard drive. There's a folder on the drive called Night Of. I didn't give you a copy of what, because I think you should see it for the first time with Nolan Briggs in the room. She held my gaze. Dad, it's bad. What he did, it's worse than you know. A knock at the conference room door. I said, come in, and Nolan Briggs opened the door and stood in the frame. His jacket off his sleeves rolled to the elbows, a legal pad already in his hand. He looked at the hard drive on the table, then at Melissa, then at me. I think, he said carefully, that I need to sit down. Nolan Briggs sat down, set his legal pad on the table, and looked at the hard drive the way a doctor looks at an X-ray, when he already suspects what he is going to find, but needs to see it confirmed before he says anything out loud. He plugged it into his laptop. The folder structure loaded on his screen, and he scrolled through it slowly, his expression neutral in the practiced way of a man who has spent 30 years prosecuting fraud cases and has learned to keep his face from doing his thinking for him. When he reached the folder labeled Night of, he stopped scrolling and looked up at Melissa. "Did you open this one?" he asked. "Yes," she said. "Once. I closed it after the first file." Nolan nodded and double-clicked the folder. Inside were 11 files organized chronologically. The first was a photograph taken on a phone time-stamped 11 days before the fire, showing my barn from the south access road, with handwritten annotations on a printed overlay, marking the woodshed door, the east wall ventilation gap, and what the notation called primary ignition point. The second file was a text document, a timed sequence laid out in 15-minute intervals, describing exactly how the fire was intended to spread from the barn through the covered walkway into the main house's south wall, with notes on wind direction, humidity levels for that week, and the estimated response time of the nearest fire station. Derek had planned the destruction of my home, the way an engineer plans a demolition. Nolan read through the sequence document without speaking. His pen moved twice across his legal pad. Then he looked at me and said quietly and without drama, "This is the most complete record of premeditation I have seen in 11 years of prosecuting arson cases." Renee Stokes came in 15 minutes later, called by Nolan's assistant. She sat beside him, reviewed the files he indicated, and pulled out her own documentation, the physical evidence report from the burn site, which she had completed 2 days earlier. She laid it on the table beside Nolan's laptop, and they compared the annotated photograph against her burn pattern analysis without speaking for nearly 2 full minutes. The primary ignition point marked in his photograph, Renee said, finally tapping the screen, matches the deepest char concentration I recorded at the scene to within approximately 2 feet. She said it the way scientists state things, without inflection, without emphasis, and somehow that flatness made it land harder than any dramatic pronouncement could have. Sandra Voss appeared by video call on Nolan's laptop 20 minutes into the meeting. A composed woman in her early 50s with reading glasses pushed up on her head and a spreadsheet open on the screen behind her. She had been Derek's internal accountant for 6 years, and 4 weeks before the fire, she had begun quietly copying financial records onto a personal encrypted drive, after noticing a series of transactions she could not reconcile against any legitimate project expense. She walked us through 3 specific line items. The first was a $50,000 withdrawal from the Aspen Ridge Project Development Fund, coded as equipment procurement, and paid to a vendor registered in Nevada, whose business license had been issued 9 days before the payment, and listed no physical address. The second was a $35,000 payment to Pacific Baseline Survey Associates, coded as legal consultation. The third was an $11,000 purchase logged as landscaping materials, broken into 3 separate transactions on 3 consecutive days. A structuring pattern Sandra explained, used to keep each transaction below the $10,000 federal reporting threshold. Credit card records attached to that third transaction showed purchases at a fuel supplier in Victorville, a hardware store in Hesperia, and an electronics retailer in San Bernardino. Nolan pulled up the itemized receipts Sandra had obtained. Aviation-grade accelerant, heat-resistant work gloves, size large, a cellular signal jamming unit. All purchased 8 days before the fire. Nolan set his pen down and looked at the ceiling for a moment, the way he had in the recording session, when he heard Derek's voice on Evelyn's audio files. Then he looked at me. "Mr. Greer," he said, "I want to walk you through the charges as they currently stand, because I believe you have a right to hear this directly." He turned his legal pad to a fresh page. Arson in the first degree under California Penal Code, Section 451, the intentional burning of an inhabited structure. Because the fire was set while the property was your primary residence, and because the planning documents demonstrate clear intent, This carries a sentence of 3 to 8 years, but given the evidence of financial motivation and the degree of premeditation, we will be arguing for the upper term." He paused. "Real estate fraud under Business and Professions Code, Section 10177. Forgery of public documents under Penal Code Section 470. Insurance fraud under Penal Code Section 550. The policy alone adds up to 5 years per count, and obstruction for the structuring of the equipment purchases." He counted 5 charges, tapping his pen against the pad once for each. Melissa was sitting very still beside me. Her water glass was untouched. Her hands were in her lap, now no longer pressed flat on the table, and I could see from the set of her shoulders that she was holding herself the way people hold themselves when they are somewhere between fury and grief and have not yet decided which one is going to win. Gavin Locke's written statement arrived by secure fax during the meeting his attorney had finalized it that morning. It confirmed every detail of the night: the dark gray pickup, the drive up the access road with headlights off the fuel container, Derek's precise instructions about the ignition sequence, and the fact that Derek had returned to the truck afterward and said in Gavin's recollection words to the effect that by morning the old man would have nothing left worth arguing about. Nolan read the statement, initialed the last page, and added it to the stack of documents that had been accumulating on the table for the past hour. Then he looked at me and asked the question I had been waiting for since I first walked into Cole Hartley's office and handed over the camera footage. "Mr. Greer, are you willing to take the stand as a witness?" I thought about Ray's thermos on the shelf above the fireplace, the shelf that no longer existed in the house, that no longer stood on the land that was still mine. "That," I said, "is the least I owe my brother." Judge Patricia Weld had come down from Santa Barbara County with a reputation for running tight courtrooms and a documented intolerance for procedural delay. She was a small woman in her early 60s, with silver hair cut close and reading glasses she wore on a chain around her neck. And from the moment she took the bench on the first morning, she made it clear that the pace of this proceeding was going to be hers to set and no one else's. I sat in the gallery on the left side, third row, in a plain gray suit. Not the robe, not the bench. I was a witness and a victim, and I was going to conduct myself as exactly that, nothing more, because I understood that the integrity of the outcome depended in part on no one being able to point at me and argue that Walter Greer had used his position to shape the result. Nolan had been clear about that, and I had agreed without reservation because he was right. Melissa sat beside me. She had filed for divorce 10 days earlier. She had told me about it on the phone, her voice steady and matter-of-fact, in the way it gets when she has already done her grieving privately and is now simply reporting a decision. I had not said much in response. There was not much to say that she had not already said to herself. Patterson moved immediately on the first morning to suppress the camera footage, arguing that the installation of recording devices on private property without explicit notification to visitors constituted an invasion of privacy under California Penal Code, Section 632. Nolan countered in 2 sentences. Section 632 applies to confidential communications, not to activity conducted openly on another person's property without permission, and a man who enters land he does not own to commit arson has no reasonable expectation of privacy while doing so. Judge Weld denied the suppression motion before Patterson finished sitting back down. The physical evidence came in without significant challenge. Renee Stokes testified for most of the first day, walking the jury through her burn pattern analysis. The 2 independent ignition points, the aviation accelerant residue found on the barn foundation, and the annotated photograph from the hard drive matched against her site measurements. Patterson's cross-examination lasted 40 minutes and produced nothing useful for the defense. Sandra Voss testified on the second morning about the financial transactions, the $50,000 withdrawal, the Pacific baseline payments, the structured purchases of the accelerant and equipment. She was precise and unhurried on the stand. answering Patterson's challenges with the particular confidence of a woman who has spent decades working with numbers and knows exactly what they prove and what they don't. The jury watched her the way juries watch accountants who know what they're talking about, with the focused attention of people who are doing arithmetic in their heads and finding that it keeps coming out the same way. Gavin Locke testified on the afternoon of the second day. He had accepted a plea agreement under which he would serve between 18 months and 3 years in exchange for his full cooperation. He took the stand in a gray county-issued shirt and described the night of the fire with the flat, careful accuracy of a man who has rehearsed his account enough times to know exactly where the edges of it are. He described the drive up the access road with the headlights off. He described Derek getting out of the truck with the fuel container. He described waiting in the cab for 11 minutes while the glow started behind the woodshed. And he described Derek climbing back into the passenger seat afterward and saying in words, Gavin quoted exactly, "By morning, the old man won't have a thing left worth arguing about." Patterson attacked his credibility for an hour. Gavin did not waver on a single material fact. Evelyn Nash took the stand on the morning of the third day. She had dressed carefully, a dark blue blazer, her hair pulled back. Her hands folded on the railing in front of her with the composed stillness of a woman who has been preparing for this moment for months and has decided exactly how she intends to conduct herself through it. She walked Nolan through the recordings, methodically identifying each clip by date, describing the circumstances under which it was made, and confirming the voice on the recording as Derek Calloway's to the best of her knowledge and belief. A forensic audio analyst had already testified that the voice patterns on the recordings matched a known sample of Derek's voice with a confidence level exceeding 94%. When Nolan reached the clip from March, the one where Derek discussed the environmental citations as a checklist, he played it for the jury through the courtroom speakers and then asked Evelyn a single question. Ms. Nash, at the end of that recording, Mr. Calloway makes a statement about the property owner. Can you tell the jury what he said? Evelyn looked at the jury, not at Nolan, not at Derek. She looked at 12 people who had been sitting in that room for 3 days, absorbing evidence, and she said in a clear and level voice that carried to every corner of the courtroom. The room went completely quiet. Not the managed quiet of a courtroom waiting for the next question. A different kind of quiet, the kind that falls when something has been said that everyone in the room understands the full weight of simultaneously. I felt Melissa's hand find mine on the armrest between us and grip it hard, and I let her and I looked at the jury, and 3 of them, a retired school teacher in the second seat, a postal worker in the fourth, a woman about Melissa's age in the back row, were looking not at Evelyn and not at Derek, but up at the bench where Judge Weld was sitting, the bench where a farmer had once presided over this county's courts for 22 years. Judge Weld did not gavel for order. She let the silence hold for exactly as long as it needed to, and then she said quietly, "You may continue, Mr. Briggs." Patterson's cross-examination of Evelyn lasted 22 minutes. He challenged the legality of the recordings, questioned her motivations, and suggested she had fabricated or edited the audio to settle a personal grievance against her former employer. Evelyn answered each challenge with the same level precision she had brought to every question Nolan had asked, and when Patterson suggested the recordings proved nothing about Derek's actual intentions, she looked at him steadily and said, "He described the fire in that recording 2 weeks before it happened. I'm not sure what other intentions you'd like me to account for." Patterson sat down. Derek had been watching Evelyn throughout her testimony with an expression that had moved over the course of 3 days from controlled composure to something rawer and less managed. By the time Evelyn stepped down from the stand, his jaw was set so tight I could see the muscle working in his cheek from 3 rows back, and his eyes had the look of a man who is running through options and finding one by one that each of them has already been closed off. Melissa leaned close to me during the recess and said very quietly, "He actually thought you'd never find out." I thought about the robe hanging in my office. I thought about Ray's thermos. I thought about a man who had looked at my life and seen only an obstacle. "He didn't know what he was looking at," I said. I took the stand on the afternoon of the third day. I had testified in courtrooms hundreds of times in my career, not from the witness box, but from the bench, which is a different thing entirely. From the bench, you control the room. You set the pace, manage the temperature, decide when something has gone far enough and when it hasn't gone far enough yet. From the witness box, you give up all of that. You sit where you are told to sit, answer what you are asked to answer, and trust that the structure of the proceeding will do what it was designed to do. I had presided over that structure for 22 years. I understood its design better than almost anyone in that building. And I understood, sitting in the witness chair for the first time in my professional life, that the best thing I could do for this case was to be exactly what I was, a 71-year-old man in a plain suit, without title, without authority, without anything except what I had seen and what I had done and what had been done to me. Nolan began with the history. He asked me to describe the farm, and I described it: the acreage, the timber construction, the well, the water rights, the 30 years of work that Ray and I had put into that land before Ray died and left it to me. He asked me to describe Derek's first approach, and I described it: the dinner in Sacramento, the handshake, the quality of the questions that were slightly too informed to be casual. He asked me to describe the citations, and I described them one by one, reading from the dates in my documentation log, a copy of which Nolan had already entered into evidence as Exhibit 14. He asked me to describe the night of the fire. I described driving south on the highway, with the notification lighting up my phone screen. I described pulling onto the shoulder and watching the footage load the truck moving up the access road with its headlights off. I described the smoke alert and the glow visible from 8 miles out and turning up the access road to find my house fully engulfed. I described Frank Morrow standing at the gate with his notebook. I described Derek arriving 18 minutes after I did and saying that he had come as fast as he could, and the particular quality of the satisfaction I had seen cross his face before he arranged it into something else. I kept my voice level throughout. Not because I was not angry, I was in the deep settled way that anger becomes when it has had months to move past heat into something colder and more durable, but because I had learned a long time ago that a witness who loses his composure loses the jury's trust, and I needed those 12 people to hear what I was saying rather than how I was feeling. Nolan asked his final question. "Mr. Greer, during the period of this dispute, did you at any point use your position as Chief Judge of the Silver Ridge County District Court to influence the investigation or prosecution of Derek Calloway?" "No," I said. I recused myself from the case the moment I saw my name on the filing. Every warrant issued in this investigation was signed by a judge I did not appoint and have never worked with directly. Every prosecutorial decision was made by Mr. Briggs, who was assigned specifically because he had no prior professional relationship with me. I appeared in this proceeding as its victim, and I have conducted myself as exactly that. Patterson stood for cross-examination with the energy of a man who has been waiting for his turn and intends to make the most of it. He was good at his job. I had watched enough attorneys to know the difference between competent and genuinely skilled, and Patterson was genuinely skilled. He started wide and moved in slowly, the way a good cross-examiner always does. He established that I had installed cameras on the property without informing anyone. He established that I had withheld the footage from law enforcement for several hours after the fire before transferring it to Cole Hartley. He established that I had a personal financial interest in the outcome of the criminal case since a conviction would support my civil claims for damages. Each point was accurate. Each point was designed to suggest that my actions throughout had been calculated and self-serving rather than defensive and reasonable. I answered each question directly, without elaboration, without defensiveness, the way I had always instructed witnesses to answer when I was preparing them from the bench. Then Patterson leaned forward slightly and asked the question I had been expecting since he rose from his chair. "Mr. Greer, isn't it true that you, a sitting judge with 22 years of experience in this county's court system, had significant advantages over my client in this dispute? That an ordinary property owner simply would not have had?" I looked at him steadily. "I had the same advantages any property owner has," I said. "I read the documents I was sent. I kept records of what happened to me. I reported threats to law enforcement when I received them. I preserved evidence when I found it." I paused. "If those things seem like advantages, I'd suggest the bar has been set too low for the rest of us." Two jurors in the front row shifted in their seats. Judge Weld did not react, but I saw her pen stop moving on her notepad for just a moment. Patterson regrouped and tried another angle. He asked whether I had ever considered at any point simply selling the property and avoiding the conflict entirely. "My brother died on that land," I said. "My father's tools are buried in that ash. I planted a stone at the edge of the east field with my brother's name on it, and I visit it every morning when the light is right." I looked at Patterson without blinking. "You don't sell the place where the people you love are buried. You protect it. That's not stubbornness. That's what family means." The room was very quiet. Patterson looked at his notes. He looked at Derek. Derek was sitting at the defense table with his hands flat on the surface in front of him, staring at the table with the expression of a man who has run out of moves and knows it and is no longer trying to hide that he knows it. Patterson asked one more question. He asked whether I believed Derek Calloway had underestimated me. I considered that for a moment, genuinely considered it, not for effect. I thought about the handshake at the dinner in Sacramento. I thought about the offer at 43 cents on the dollar. I thought about the text message that said you should have sold. I thought about the night I stood in front of my burning house and watched a man arrange his face into grief while his eyes said something else entirely. "He didn't underestimate me," I said. "He never saw me at all. He looked at this land, and he looked at my age, and he looked at the way I dress and the truck I drive, and he decided I was the kind of man who could be moved out of the way." I let that settle for a breath. He was wrong about what kind of man he was looking at, but that was always going to be his problem, not mine. Patterson sat down. Nolan stood for redirect and asked a single question. "Mr. Greer, when you heard Mr. Calloway's recorded statement that farmers don't win, what did you think?" I looked at the jury. All 12 of them were looking back at me. "I thought about my brother," I said. "Ray grew up farming this land. He built something from nothing with his bare hands, and he was smarter and more decent than most men I have ever met in a courtroom. And I thought," I stopped for just a moment, not for drama, but because the truth of it needed a breath before it could come out right. "I thought that Derek Calloway had never once in his life built anything. He had only ever taken things. And a man who has only ever taken things has no idea what a man who builds things is capable of defending." I stepped down from the witness box, walked back to the gallery, and sat beside my daughter. Melissa did not say anything. She did not need to. She took my hand, the same way she had taken it during Evelyn's testimony, firmly without a hesitation, and held it. And I let her, and we sat together and waited for whatever was going to come next. The jury went out at 4:17 in the afternoon on the third day and came back at 11:22 the following morning. 6 hours and 43 minutes of deliberation for a case that had taken months to build. I had seen juries come back faster on cases with less evidence, and I had seen juries take 3 days on cases that seemed straightforward from the bench. 6 hours and 43 minutes told me nothing predictive about the outcome, and I had learned a long time ago not to try to read deliberation time as a signal of anything except that 12 people were taking their responsibility seriously, which was exactly what you wanted them to do. I spent the evening in my motel room with a cup of coffee and the documentation folders spread across the bed, not reviewing them for any purpose, but because they were familiar and the familiarity was steadying. Melissa called at 9 o'clock. She did not ask me how I thought it was going to go, which told me she had already decided not to speculate, and I loved her for that. We talked for 20 minutes about the farm, about what the reconstruction might look like, about whether to keep the same floor plan or adjust the kitchen layout, about whether Ray's tree had come through the fire undamaged. It had. I had checked the morning after the fire, and the Douglas fir was untouched, the stone at its base still upright, still readable. We said goodnight, and I turned off the light and lay in the dark and thought about Ray. The courtroom was fuller on the verdict morning than it had been at any point during testimony. Word had moved through the community the way it always moves in small county towns, not through any announcement, but through the accumulated whisper of people who work in and around courthouses and understand what a returning jury means. There were reporters in the back rows. There were residents from the foothills communities who had driven in without being asked. Frank Morrow was in the fourth row on the right side in a clean flannel shirt with his notebook in his breast pocket, because Frank Morrow was the kind of man who showed up. Melissa and I sat where we had sat throughout the trial. She was wearing a dark green coat, and her hair was down, and she looked like her mother in a way that hit me somewhere low and private, and I did not say so because there are things a father keeps to himself. Derek sat at the defense table in the same charcoal suit he had worn on the first day, which struck me as either a statement of confidence or a failure of imagination, and I suspected the latter. Patterson sat beside him with a legal pad he was not writing on. Derek's posture had changed since the first morning. He still sat straight, but the quality of it was different now. The rigid straightness of a man holding himself together by effort, rather than the easy straightness of a man who has never considered the possibility of losing. Judge Weld took the bench at 11:15. She asked whether the jury had reached a verdict. The foreperson, a retired civil engineer named Gerald, according to the juror list I had memorized during voir dire, stood and said that they had. On the charge of arson in the first degree under California Penal Code, Section 451. Gerald read his voice steady and unhurried. We, the jury, find the defendant, Derek Calloway, guilty. Derek's shoulders dropped a fraction of an inch. It was barely visible. Patterson put his pen down on the legal pad. On the charge of real estate fraud under Business and Professions Code Section 457, we find the defendant guilty. Melissa's hand found mine on the armrest. I did not look at her. I kept my eyes on Gerald because I had presided over enough verdict readings to know that looking away during one was a way of not being fully present for something that deserved your full presence. On the charge of forgery of public documents under Penal Code Section 470, we find the defendant guilty. Patterson leaned toward Derek and said something. Derek did not respond. He was staring at the table in front of him with the fixed, unseeing look of a man whose internal calculations have just produced a result he cannot accept. On the charge of insurance fraud under Penal Code Section 550, we find the defendant guilty. The reporter in the second row of the press section was typing. The woman about Melissa's age who had been watching Walter throughout the trial, the one who had looked up at the bench during Evelyn's testimony, pressed both hands flat over her mouth. On the charge of obstruction of justice, we find the defendant guilty. Gerald sat down. The courtroom held its breath for exactly one beat, And then the sound came in, not a cheer, not applause, but a collective exhalation. The sound of a room full of people releasing something they had been holding since the trial began. Judge Weld gavelled twice, not sharply, just enough to maintain decorum without fighting the room. Nolan rose and requested immediate remand, arguing flight risk given the severity of the charges and the degree of financial resources available to the defendant. Judge Weld granted it without hesitation. Two sheriff's deputies moved to the defense table, and Derek Calloway stood and held out his wrists, and the cuffs went on with a sound that was very small in that large room, but that seemed to carry further than it should have. He turned as they led him toward the side door. Not to look at me, I thought, but to look at Melissa. She was looking back at him. Her expression was not angry, and it was not sad. It was the expression of a person who has finished accounting for something and has nothing left to feel about it, except the clean emptiness of a closed ledger. Derek looked away first. Judge Weld scheduled formal sentencing for 30 days, out at which time Nolan would present the full scope of the financial damage for consideration. She noted for the record that the court would be receiving victim impact statements prior to sentencing, and that restitution calculations were being prepared by the County Financial Crimes Unit. I did not move for a long moment after the gavel fell. Frank Morrow caught my eye from across the room and gave me a single nod, the particular nod of a man who kept notes and showed up and never asked for anything, and was glad the thing had ended the way it ended. I nodded back. Melissa turned to me in her seat. Her eyes were wet, finally, the tears coming now, that there was nothing left that required her to hold them back. She did not try to stop them, and I did not suggest she should. "Dad," she said. Her voice broke on the single syllable in the particular way voices break when a person has been strong for a very long time and has just been given permission to stop. I put my arm around her shoulders and held her the way I had held her on the 4th morning after her mother died, when she had come downstairs and made breakfast and told me we were going to be okay, and I had known she was right, but had not been able to say so. "I know," I said. "I know." Outside the courthouse, the California afternoon was bright and cool. The kind of clear autumn day that makes the San Bernardino foothills look like something painted rather than something real. I stood on the steps with Melissa beside me and let the sun hit my face, and thought about the land waiting up on the ridge, the ash, the stone, the Douglas fir standing untouched at the edge of the east field. I thought about what I was going to build back. Judge Weld sentenced Derek Calloway to 25 years in California State Prison 31 days after the verdict. I was not in the courtroom. I had given my victim impact statement in writing, as was my right under California Penal Code, Section 1121. And I had chosen not to attend because I had nothing left to say to Derek Calloway that I had not already said from the witness box. The morning of sentencing happened to be the first day the construction crew was breaking ground on the new foundation, and I chose the foundation over the courtroom without any difficulty at all. The crew arrived at 6 men in work boots and canvas jackets, a concrete truck, and a small excavator that had to be walked up the access road in low gear because the trail was still too soft from the spring rains. I stood at the edge of the cleared site with a cup of coffee and watched them work. And I thought about the summer Ray and I had poured the original foundation. How young we were. How certain. The certainty of young men building things is one of the most honest feelings a person can have, because it is built entirely on effort and has no room in it for doubt. The new house would sit on the same footprint as the old one, same orientation, same view of the Douglas fir from what would become the kitchen window. The design was different in the ways that 30 years of California fire seasons demand concrete board, siding a metal roof rated for ember resistance, double-pane tempered glass, and a water storage tank buried in the hillside that could supply the property independently for 45 days. Ray would have approved of the tank. He always said self-sufficiency was not stubbornness, it was preparation, and in his experience the two things looked identical from the outside. The civil case resolved 6 weeks after the criminal sentencing. Judge Weld issued a comprehensive order vacating every citation ever levied against my property, declaring the Pacific Baseline Boundary Survey fraudulent and legally void, and confirming on the public record that my parcel had never fallen within any jurisdiction claimed by Callaway Group. The court ordered Derek to pay full restitution for the destroyed structures, the investigation costs, and the legal expenses I had incurred across 14 months of documented harassment. The Callaway Group filed for bankruptcy 8 days after the civil judgment. Evelyn Nash received a formal commendation from the State Attorney General's office, which she told me about in an email that ended with one sentence: "I grew up on a farm." I always knew which side I was on. I printed it out and put it in the drawer of my new desk when the house was finished, enough to have furniture in it. Melissa's divorce was finalized in the spring. She kept her professional name, Melissa Greer, dropping the Callaway entirely, and went back to the conservation nonprofit in Sacramento. She came up to the farm every other weekend while construction was underway, sometimes bringing colleagues who had never seen the foothills in early summer. Watching her walk that land, pointing out the trail through the pines, crouching to show someone how the water moves through the creek bed after rain made something in my chest loosen that I had not known was tight. She told me in March on a Sunday call that she was going to be a mother in August. Her voice had that careful brightness I recognized, but different this time, unguarded, in a way she had never been when she talked about Derek, because this was something she had chosen entirely for herself. I sat down in my camp chair at the edge of the cleared site, looked at the ridge going gold in the late afternoon light, and said the truest thing I could think of, that Ray would have been beside himself with happiness, and that I intended to be also. Frank Morrow came for coffee the morning the crew finished the porch. He walked up the access road, the way he always came, on foot, unhurried, and stood at the edge of the gravel looking at the new house. The way a man looks at something he was not sure was going to happen, and is glad to see that it did. I poured 2 cups. We sat on the new porch board, still smelling of fresh-cut lumber, and looked out at the property in the quiet of a morning with nowhere to be. "Looks right," Frank said. "It does," I said. He reached into his jacket and set a strip of homemade deer jerky beside my coffee cup without comment. We sat the way good neighbors sit without needing to fill the space between them. After Frank left, I walked to the eastern field. Ray's stone was undisturbed, his name still clear in the granite holding the morning light, the way granite does, as though it has all the time in the world. I touched the top of the stone once, and turned back toward the house. The porch light was on. The kitchen window was lit. Melissa's car was in the drive. The new house sat on the old foundation under the same ridge and the same sky, and it looked from the edge of the eastern field the way something looks when it belongs exactly where it is. I went inside, and I made breakfast for 2. This has been my family story, and I won't pretend I handled every part of it perfectly. I stayed silent too long. I watched the warning signs and told myself patience was wisdom. If this family story taught me anything, don't wait the way I waited. When someone shows you who they are, believe them. Protect the people you love before the fire, not after. My personal belief: a man who has never built anything has no right to take what another man built with his hands and his years. Titles don't make character. Actions do, especially the ones taken when no one is watching. And I believe God has a way of making sure the truth outlasts the lie, even when everything else burns. These grandpa stories are never just about land or law. These grandpa stories are about what a family endures to remain a family. And these grandpa stories remind us that real justice moves slowly, but it never stops moving. If this family story reached something in, you share it with someone who needs to hear it today. Leave a comment. I read everyone. Subscribe and stay close because there is more to come. Thank you for staying until the very end. It means everything. One final note. Some stories on this channel include fictionalized elements crafted for storytelling and educational purposes. If that's not what you're looking for, we completely understand. Please explore other content that speaks to you.